There were some additional provisions about if the petitioner was ever incarcerated, because he had had several arrests related to alcohol use, that he would be assisting with transportation. So all of those were taken into consideration given what was happening at that time. The petitioner was arrested for his fourth DUI, which we've included in our motion, 23 TR 1940, and was sentenced on March 21st of 2024. And I provided the court with the journal entry related to that case, which is our Exhibit 6.
All right, I'll take judicial notice of Respondent's Exhibit 6.
Thank you, Your Honor. I'm going to kind of go down the line here. Exhibit 7 and 8 are also related to the same incident. Those are both of his probation violations, one on August 19th of 2024 and one on March 7th of 2025.
Now, remind me, when the June of 2023 agreement was entered, had he already been charged with 23 TR 190, or did that come after?
No, I think he had, and Cheyenne can correct me if I'm wrong, nod yes or no. I think he had been arrested recently. Is that correct, Cheyenne, or no?
Okay. So those provisions that were set out were taken into consideration, that he had been arrested for fourth DUI, but he didn't actually have a conviction until after the agreement 3/21 of 24. But what has happened since that time is probation violations.
That's correct.
Okay, keep going. Thank you.
So the first probation violation was less than 5 months after he was sentenced, where the petitioner admitted to drinking alcohol. And then the second was in March of this year, where he failed to participate in mandatory treatment associated with his DUI. I would also point out for the court, this is a felony DUI. I know the court's aware of that, given that it's number 4, and carries with it some pretty significant ramifications. So beyond that, which my client has concerns about, she wasn't made aware of the probation violations in real time. She didn't know anything about them until
All right, guys, buckle up because this case starts heavy right out of the gate. In just a few seconds, the courtroom establishes a troubling pattern involving repeated arrests, alcohol abuse, and a fragile custody arrangement already under strain. The attorney carefully lays out how prior agreements were built around safety concerns, especially the risk of incarceration. Even before the judge speaks at length, you can feel the weight of the history here. This isn't a minor dispute or a one-time mistake. It's the foundation of a case where past behavior is about to collide with present responsibility, setting the tone for everything that follows.
Months or even years after the probation violation occurred. So the petitioner has failed to inform her of that. Now, of course, there's nothing that requires him to let her know that he's had a probation violation, but she likely would have initiated an action earlier had she known even about the first probation violation when it occurred back in 2024. But she just wasn't made aware of it at the time that it occurred. So here we are now, in 2025, filing a motion asking for these changes. My client received communication from the petitioner's significant other. He and significant other recently had a baby together. Her name is Haley, and those are in Exhibit 11. And the petitioner, the respondent, and respondent's significant other all know each other. So they have previously run in the same social circles. My client is friendly with Haley, is her name. And so they had established a friendly relationship even prior to her getting in a romantic relationship with the petitioner. So in August, so just a couple of months ago, the petitioner's significant other reached out to Cheyenne, to respondent, about concerns that she had about the petitioner's continued alcohol use. Page 2 of that exhibit, she tells my client that she has thoughts about calling his probation officer, but doesn't know that it would do any good. She has, on page 3, provided examples specifically of him drinking where he's missed major events. Her sister's baby shower. There have been events for school that he's missed.
All right, guys, this is where the situation starts to unravel fast. The court learns that the fourth DUI wasn't just serious, it was followed by probation violations that happened almost immediately. What makes this worse is the quiet nature of it all. The violations weren't disclosed, not communicated, and not addressed until much later. This creates a sense that the problems didn't stop after sentencing, they continued in the background. The judge listens as a pattern emerges: relapse, non-compliance, and delay. At this point, it's no longer about one bad decision, but about whether accountability exists at all.
Page 4, Haley talks about how she cannot trust him to stay at home with the children. She has children from a previous relationship. Obviously, the petitioner has Hayden, and then she just recently had a baby that is the petitioner's as well. So there have been multiple instances where she said that she can't leave the kids home because she doesn't trust him.
Okay. It looks like most recently he's lost his job. So, Mr. Hoggaboom, you have seen all of these things and texts, and you're aware of your probation violations and your alcohol issue. And I don't know the status of the Red House or your movement, but if you don't have employment, that's problematic. So what is going on with you in relation to treatment? This is not a shared custody situation anymore. This is not a workable, safe shared custody situation the way it currently exists.
I'm I'm self-employed. I'm hoping to get a pumping job. I was offered. They have 2 more people to interview, but it's looking like I might get it. And it'd be for Vess Oil Corporation. Opportunity of a lifetime. But
Who?
Vess Oil Corporation. They
spell that?
BESS.
Okay.
How
were you related to Albert Hoggaboom?
He was my uncle.
Okay. All right. So, Kathy
Was my...
I learned recently passed away. She was not your mother.
No, she was my cousin.
Okay.
All right, guys, this is the moment that shifts the entire case emotionally. The most damaging evidence doesn't come from police records. It comes from inside the home. Text messages from the petitioner's own partner describe missed events, broken trust, and fear about leaving children alone with him. That's a gut punch in any courtroom. When the person closest to you is questioning your sobriety and reliability, it carries serious weight. This isn't speculation or accusation, it's lived experience. You can almost feel the judge recalibrating the case as safety concerns move from theoretical to personal and immediate.
So you resigned from Hoggaboom, which you had no interest in. You were just an employee.
Yes, ma'am.
How long did you work there?
Almost 7 years.
Okay. And who are you currently living with?
Haley. We have a house together in El Dorado.
And it's not this red house out of town?
No, we moved out of that because it wasn't getting done like it was promised and we needed something better.
Okay. Are you renting?
Yes.
And where does your daughter attend school?
Ewalt Elementary in Augusta.
Okay. And what's your probation status?
I'm still on it for until March, I think. March or April.
So it was extended to 2026.
Yes.
And are you on community corrections?
Yes.
Okay. Who's your ISO?
Danny McKenzie.
Okay. Yeah, I think I saw that on the voluntary sanctions that you've done. What is your treatment status?
It's active. I go once a week.
Where are you going?
ARC. It's in Augusta, ARC.
Okay. Do you have a valid driver's license?
Yes.
Can you provide proof of that to Miss Henry, please? Or give her the information so she can go online and look at it?
Oh, yeah. Let me get it.
I don't want you to give it over the
Oh, okay.
broadcasting.
Email or something?
I need you to email it to her. Do you have access to a computer that you can email?
I can once I get home. We're on a field trip right now. Or I can do it on my phone, I guess.
And Your Honor, I would be interested to know that because I think the court has seen our exhibits show that there was a ticket just last month and a summons related to a suspended driver's license.
That was back in March. I didn't even know it was suspended because I still had it. And when he pulled me over, I still had the actual license, and he said the paperwork saying it was suspended probably got sent to an old address. And that was why, but I got it back in July, I believe.
Do you have an interlock device?
Yes, I do.
All right, guys. Now the judge steps in and takes full control of the room. The questions come fast and precise. Employment, housing, probation status, treatment, and driving privileges. Each answer raises new concerns, especially when contradictions surface. The suspended license issue hits hard because it directly impacts child safety. The judge isn't hostile, but she's clearly skeptical. This is the moment where explanations start sounding thin. You can sense the shift from evaluation to warning. The court isn't just listening anymore. It's measuring risk, and the margin for error is disappearing.
Okay, well, yeah, I'm just not sure about this week on, week off, until things calm down with you and you've completed treatment and you've got a regular job and some stability. So are you objecting to reducing your parenting time with mom having primary residential custody?
I mean, I'd like to, but I don't have an attorney, so I don't really have a leg to stand on.
Well, no, you can represent yourself, but I just think things have gotten chaotic and a little too far out of control.
I understand.
And I do want confirmation that you have a driver's license, because if you don't have a driver's license and you get stopped and they arrest you because it's an arrestable offense, then they're going to take her into custody. Plus, she's going to see the traumatic
Yeah, I understand.
actions of you being handcuffed and put in a police car and all that kind of stuff. So that's why that's so significant, to make sure that you're not responsible for driving with her on a suspended license. So that has to be verified for sure.
All right, guys. This is the emotional peak of the hearing, and the judge doesn't sugarcoat a single word. When he admits he drank recently, the courtroom changes instantly. The judge explains in plain language that a fourth DUI isn't just serious, it's prison-level serious. She calls out the reality of addiction, the absence of control, and the danger of denial. This isn't a lecture, it's a hard truth delivered with authority. Every sentence reinforces that treatment without sobriety means nothing. At this point, the stakes are unmistakable. Continued drinking equals lost freedom and lost parenting time.
And you got to get treatment completed, and I've got to get a record from them that you've successfully completed. And then I think that sober link will make a difference for a while. Miss Henry, I mean, you can't look at somebody and judge them, but it doesn't look like to me he's real strung out, or that he's actively using daily. When was the last time that you consumed alcohol?
Probably last Thursday, I think.
Okay, well, you're still using. You can't use and be in treatment just to get through treatment.
I understand.
You're on a fourth DUI. They are now felonies where you go to prison. There's no more county jail time and you're going to be stuck in a county jail for 90 days or 6 months or 30 days or 5 days. You go to prison. You're going to go to prison. That means you can't control your drinking. That means, and you don't have good judgment when you drink. That means that you're an alcoholic.
All right, guys, this is where consequences become official. The judge grants the modification, reduces parenting time, and lays out strict conditions: treatment completion, sober monitoring, proof of licensing, and stable employment. What stands out is the balance. The court isn't punishing out of anger, it's protecting a child while leaving the door open for change. A 6-month review offers hope, but only if real effort follows. The message is clear: love alone isn't enough. Accountability, sobriety, and stability are now the price of remaining involved as a parent.
That means that you cannot drink at all. Not one drink, not one beer, not one shot, not anything. Ever again. And I'm guess you're not getting that message in treatment. You're not accepting that. So I'm going to grant their modification request. What's your parenting plan proposal? Where do I find that? Right here on Exhibit 3.
Yes, Your Honor.
And frankly, I'm not calling you a bad guy. I'm not saying that you're a bad guy or a bad father or anything else. But Mom would be remiss not to protect her at all levels. And if something happened, she wouldn't be able to live with herself. So, like I said, I have faith that you can turn things around, but I have to see evidence of that.
Understood.
So she wants to go to every other weekend, and you have to sign up and participate over those weekends because she's not asking for supervised. She's not asking to terminate until things happen. She is giving you the benefit of the doubt and the benefit of visitation, is what she's proposing. And I think it's reasonable that you participate in Sober Link and have every other weekend. You obviously can attend any school activities or anything else that she's doing. And I need a letter from your alcohol and drug counselor as to where you are in treatment.
Okay.
And when it's contemplated that you'll be done. And it sounds like to me, if you're still drinking, you need to up your treatment.
Okay.
I really am concerned about you not only going to prison on this case that's you're still on probation with Judge Hart on, but I'm concerned that if you picked up another one, and it doesn't matter if it's on your non-parenting time and you drink and get a DUI, that you're going to end up in prison. So you've got to stay sober. You've got to secure good employment, and you've got to work on yourself. And that's what you need to do with any free time that you have when you don't have your daughter. I have no doubt that you love her. Alcoholism isn't about who you love or who you don't love. It's not, it may be related to selfishness, but that's part of the addiction as well, but it's not a lack of love. But again, there needs to be some level of protection. There needs to be some level of accountability by you. And so I'll review the case in 6 months and see where you're at. See if you've completed your probation, off probation. See if you have positive counseling records. Now, before that, though, I want confirmation of a valid license and that you're in treatment.
Okay.
And then you're participating. And then we'll review it when your treatment should be completed. You should be discharged from your probation. You should be compliant with SoberLink and have employment, and we can revisit the parenting plan. Who are your parents?
JR and Sheila.
Okay. Do you tend to have difficulty during the holidays with refraining from alcohol use?
No.
Okay. What did you propose, Miss Henry, on the holidays?
Your Honor, we have listed, just passed through it here. In our motion, essentially we had the same holiday schedule, except that if there would normally be an overnight, it ends at 8 p.m. On the first day of the designated holiday, and then it resumes the next day at 8 a.m. So there wouldn't be an overnight, where my client would disagree. I think that there are a lot of holidays that the petitioner's family, and I mean most families, just there's alcohol around, and it happens later in the evening. So she tried to give him as much time as possible with the holiday ending at 8 p.m. And if it is a holiday where there's more than one day, Hayden would go back to Miss Fassig, and then she can drop her back off at 8 a.m. the next morning.
Okay. Well, I'm going to allow that for